Our last case this morning is 2019-737, State of Ohio versus Chalmer L. Brown. For the appellant, Mr. Stout.
Good morning, Your Honor. Chief Justice Connor, may it please the court, I would respectfully refer 5 minutes here for rebuttal. Okay. Again, my name is Adam Stout. I'm here on behalf of the appellant Chalmer Brown. Today's issue is to resolve a certified conflict over the criminal non-supported dependent statute under 2919.21b, which, as it was written at the time of Mr. Brown's case arising out of Xenia Municipal Court. Namely, the issue was, may a child support obligor be prosecuted for failure to pay child support under 2919.21b, where a child support order was in place for the time period specified in the charging document, but the charging document was filed after the child for whom the support was owed had been emancipated and the child support obligation had been terminated. Now, under the statute is written, because like this is with the last couple of years, this statute's been significantly amended, but at the time, RC 2919.21b had read, no person shall abandon or fail to provide support as established by a court order to another person whom, by court order decree, that the person is legally obligated to support. Now, this case was certified as in conflict with the 11th District case, State v. Hubbard, over the application of this statute and the application of this court's decision in State v. Pittman back in 2016. We believe, we're in the position that that the court should adopt the Hubbard's decision and the decision in State v. Hubbard, thereby reversing the 2nd District Court of Appeals decision in our case, Your Honor. Now, in this court's in the State v. Pittman, which was also a certified conflict case over the criminal prosecution of what were then called arrearage only orders. In Pittman, the defendant the key holding in Pittman and which the court in State v. Hubbard also heavily relied on, like they had held that Pittman was not subject to prosecution under 2919.21 for his failure to make payments on the child support order arrears established in 2006 in the 2006 order when he had the Pittman court's like the language specifically was like Pittman's liability for non-payment support ended on August 31st, 2006 when his children were emancipated. So what had happened, like in this case, he was originally indicted. The time periods went back to like 2003, 2004, 2000, went prior to, he ended it for the time periods for which he was indicted under. He was indicted back in 2009. He did not get, and in Pittman, he was not actually served with the indictment until 2013. 4 years between the time like that the state could have. That the state.
Mr. Stout, I wonder if we could talk about the facts in this case and the lead up to the action, and in that way maybe distinguish what was at issue in Pittman. Here you have, we know his paternity as of 2000. We have a child support order in August of 2001. The child is emancipated in September of 2017. And then we've got the arrearage payments ordered in December of 2017. So here, don't we already have, I mean, the arrearage is building up into that time of emancipation. There was an order in place that called for child support, which he apparently didn't pay. So can't we say here that he had been under a current obligation to pay leading up to the child's emancipation?
I said like up until the emancipate. If I understand, I think what becomes an issue is like once the child is emancipated, that's going to foreclose on the state's ability to initiate a criminal charge specifically under this statute at the time. Is what and how that is actually how the Hubbard court interpreted Pittman as well, because like when like I said, the Pittman court had said like want his criminal the language had held that his criminal liability ceased when the children were emancipated, and in addition to that, even there was three justices had concurred with him, and in the current concurrent decision, they had posited that they had discussed this like potential exception, like whether or not if it was like if they were within the statute of limitations, but at this, even though because at the same time, like because of the statute of limitations actually run out after, because due to like the 4-year delay from indictment until when he was actually served in the Pittman case. So in the concurring opinion had pointed this out, and that's like kind of what they disagree, because like the majority opinion actually had because the concurrence kind of, so it's the language of the majority then would say like this was going to be a foreclosure on all these on any kind of criminal prosecution once the order was terminated. And because actually as a result of this, you also had, and subsequent to this, even like the current statute 2919.21b actually does, it specifically, goes into, it's like it's now, it gives a myriad of much more specific conditions, like when the state can actually initiate or a criminal prosecution. That's like where if the person is legally obligated to support, they were legally obligated to support, and that amount was due and owing prior to the person's duty to pay current support terminated and remained unpaid. And the statute also expressly changed when the statute of limitations even would specifically begin to run in these cases. So because even then, because when Pittman said that when they did this, when they made the decision, they had rejected the idea that when they are referring to a court order under the 2919 statute that it's not necessarily bound by following any of the definitions or statutory provisions under the Uniform Interstate Foreign Support Act that sets like what does provide that you can still enforce an order after it's been terminated, but there's still an arrearage. So that's where that conflict had come up, Your Honors.
I'm struggling with even understanding this argument that the conduct has to be going on at the time of the indictment. That doesn't seem the way we interpret any other statutes. For example, if there were a statute that said, written like this one, that said that no person shall drive with blood alcohol content over 0.08. Do you think they would have to have that blood alcohol content at the time they were indicted, or do you think that would cover the time the conduct occurred?
No, I don't believe it would necessarily apply in this situation. I do think because like it's a nature of a court order imposing a financial obligation on the obligor that
right.
Once
but why does the person have to be under that at the time of they're actually charged? I mean, why isn't it like any other crime where you have to have committed the crime under the period in the indictment?
Well, I think what I would look at it this way, like what effectively the Pittman case is, as if it's upon the termination, it is foreclosing it.
Right, the Pittman case can't rewrite the statute. So how do you get where you are from the language in the statute?
The statute says is legally obligated because this is it's a present, as the Hubbard court had pointed out, this is a present because it is present tense. It is a present tense situation. It's not a very.
Excuse me. Take my hypothetical. What if a statute said, no person shall operate a motor vehicle if the person is under the influence of alcohol? Would they have to be under the influence of alcohol at the time that they were charged, or would it be enough when they were driving the motor vehicle?
No, because I don't think the context in that statute or in that kind of crime is that, like, when saying that it is, that it has to be, that it is, the is like it's not necessarily a specific time definition or imposition of a specific status at the time of the
counsel. Why would anybody make their last month payment then when the kid is 17 years and 11 months? I make that payment.
I mean, they would still. There's still. This interpretation. They're not entirely. This would not be a foreclosure on all criminal liability on this statute. It's like, as the Pittman court pointed out, like, these charges also could have been raised under 2919.21A2, which doesn't have the specific, like, is legally obligated or the specific requirement of or the specific imposition of the court order, the specific language in it. Second, he's also, an obligor would still be exposed to the contempt power of the court and future enforcement for any arrearages. So, I mean, the obligor isn't being completely disincentivized as a result of this.
Counsel, you're into your rebuttal time.
Okay, thank you.
Mr. Murray.
Chief Justice O'Connor, may it please the court. My name is Chris Murray, and I'm an assistant prosecutor with the Greene County Prosecutor's Office, representing the state of Ohio, in this case, the appellee. This court should hold a child support obligor can be prosecuted for failure to pay child support for 2919.21B of the Ohio Revised Code, where a child support order was in place for the time period specified in the charging document, but the charging document was filed after the child for whom the support was owed had been emancipated and the child support obligation had terminated. Based on that, the state would request this court affirm the decision of the Second District Court of Appeals in this case. If the court is looking for a test that should be applied, it would be, as I think Justice DeWine was alluding to in questions to Mr. Stout, was what is the child's status at the time the crime was committed, not when the charges were filed. And the other, I know in Pittman, as counsel was mentioning, there are 9 counts of non-support against the defendant in that case. 7 of them were dismissed either on statute of limitation issues or due process on the delay in the indictment. The 2 counts that were at issue, in those 2 counts, there was no current order for Mr. Pittman to pay current child support. And so during that, the charge period covered in the indictment, Mr. Pittman had no current order to pay support. It was an arrears only order. And that's why I believe the court said Mr. Pittman was not subject to criminal prosecution. Also, there is, Mr. Stout had mentioned about the Hubbard case. And in that case, the court looked at Pittman. The facts in Hubbard are similar to our facts here in Brown. You have, during the charge period, in the charging document, the defendant in each case had a current order to pay child support. Hubbard's decision was a split decision, and in the majority opinion, the judges looked at paragraph 19 in the Pittman case. And in there, they just focused on the language in Pittman, but Pittman's criminal liability for non-payment of support ended on August 31, 2006, when his children were emancipated. And I believe that's what others have argued, that, well, that means emancipation stops criminal liability, and the emancipation is at the date the charges were filed. However, further in that paragraph, this court went on to say, counts 5 and 6 of the indictment allege that Pittman violated 2919.21b between July 1, 2007 and June 30, 2009. But Pittman was not under a court order to support his children during that time. The 2006 orders were not for support, but instead granted judgments against Pittman for the arrearage amounts. So I think by reading paragraph 19 completely gives support for the state's position here in Chalmer Brown. Since during the charge period, Mr. Brown had a current order to pay child support. About the Hubbard decision, Hubbard is a minority decision. There's currently the other jurisdictions that have, other districts that have looked at this have disagreed with Hubbard. We have 3 cases out of the 2nd district, Ferguson, Miles, and Winslow. There's 1 out of the 10th district involving State v. Carr, 1 out of the 5th district, State v. Cornwell, and 1 out of the 8th district, Hobbs. Currently, this court has ordered a briefing stay in the Winslow case and the Carr case based on this current action, or this current case before the court. And I think going back with this case, this court should affirm the 2nd District Court of Appeals decision. And because, like I said, during the charge period, Mr. Brown had a current order to pay child support. The other thing is, if Pittman is to be read as changing the statute of limitations, that would be in conflict with Ohio law, since the statute on statute of limitations says unless otherwise provided anywhere else. There is no indication in 2919.21 as to a statute of limitations time. In fact, the statute talks about it can be classified either as a misdemeanor or as a felony. Nothing else. And so therefore, since it didn't change the statute of limitations by emancipation, I think that issue is when the child's emancipated would relate to the statute of limitations depending when an individual was charged with non-supportive dependence.
Mr. Murray, since the statute has been changed, do you have any sense for how many cases we're talking about, or for just this certain time period? Any sense for the impact of any decision we would make?
I think it would not really change. I think it would probably clarify the Pittman case by saying you look at the child's status at the time when the crime was committed, not when the charges were filed. I don't know if Justice French, you were asking about the new statute that went into effect last year, the 2919.21B, where that's subdivision 1 and 2.
Yes.
That part that deals with the arrearage, being able to pursue an arrearage after emancipation, I think that allows for what the state was trying to do in Pittman by trying to charge somebody for failing to pay an arrearage only order. I do not think that has any impact on the facts in this case or those other cases that are currently, the briefing is currently stayed with this court.
Thank you.
If there are no other questions, Your Honors, thank you for listening to this argument. And I just request the court find that a child support obligor can be prosecuted for failure to pay child support under Revised Code 2919.21B, where a child support order was in place for the time period specified in the charging document, but the charging document was filed after the child for whom support was owed had been emancipated and the child support obligation had terminated. By doing that, the court would affirm the decision of the Second District Court of Appeals. Thank you.
Thank you. Mr. Stout, I believe you have about a minute and a half.
Just briefly in response to Mr. Murray's argument, I don't, because of the statute at the time, the way the statute is written, it, rather than looking at it as for the courts to look at the status of the child, but they should be looking, they actually have to look at the status of the obligor and whether or not he was legally obligated. Otherwise it would essentially render meaningless the phrase like whether or not he is legally obligated under the statute at that time. And then when they were, and again, another thing I would just say, like, yes, we still respectfully request that the court adopt the Hubbard decision and reverse the Second District Court of Appeals in this case. Your Honor, thank you.
Thank you, gentlemen. We'll take the matter under advisement and you'll be notified of our decision. Marshall, will you adjourn court, please?
Supreme Court of Ohio stands adjourned.
Thank you.